How should I take ownership of the property I am buying? Learning how to hold title on your home can be a difficult process, and since real property is among the most valuable of assets, the question of how to take ownership of your property is of a great importance. I am Farnaz Tehrani with the Walker team. Although I'm not an attorney and cannot recommend options to you, I'm going to give you a breakdown and brief summary of the different types. Let's start out of the gate with simply number 1, sole ownership. Sole ownership can be described as ownership by an individual capable of acquiring title. Examples of common vestings are a single man or woman, a married man, woman, or domestic partner as his or her sole and separate property. For titles to property owned by 2 or more persons, here are the other forms. Number 2, community property, a form of vesting title to property owned together by married persons or by domestic partners. In California, real property conveyed to a married person or to a domestic partner is presumed to be community property unless otherwise agreed. Both parties must sign all agreements and documents transferring the property or using it as security for a loan, and each owner has the right to dispose of their own half of the community property by will. Number 3, joint tenancy, a form of vesting title to property owned by 2 or more persons in equal interests, subject to the right of survivorship in the surviving joint tenant. Title must be acquired at the same time, and the document must expressly declare the intention to create a joint tenancy state. When a joint tenant dies, title to the property is automatically conveyed to the surviving joint tenant. Number 4, community property with right of survivorship, another form of vesting title to property owned together by spouses or by domestic partners. This form of holding title shares many of the characteristics of community property, but adds the benefit of the right of survivorship, similar to the title held in joint tenancy. Upon the death of an owner, the decedent's interest ends and the survivor owns all the interest in the property. Number 5, tenancy in common, a form of vesting title to property owned by any 2 or more individuals in undivided fractional interests. These fractional interests may be unequal in quantity or duration. Each co-tenant may sell, lease, or will to his or her heir that share of the property belonging to him or her. Other ways of vesting title include a corporation, a partnership, a trust, a limited liability company, or LLC. Remember, how title is vested has important legal and tax consequences. You may wish to consult an attorney or tax advisor to determine the most advantageous form of ownership for your particular situation. Once again, I am Farnaz with the Walker team of Intero, here to educate and navigate, not speculate and fabricate. Let me know if you have any other questions or need a referral to an attorney or accountant.